This is Scott Drake, and you're watching the Legal Broadcast Network. The Supreme Court refused Monday to permit prolonged, secret questioning of crime suspects, ruling that even voluntary confessions may not be used in a federal court if the defendant was held for more than 6 hours before confessing. And we now welcome Michael Kraut from the Kraut Law Group in Los Angeles, a frequent guest here on the program. He is a former prosecutor and a deputy district attorney now in private practice. Hi, Michael. Thanks for talking to us today.
Good morning. How are you?
Good. What does all this mean? What's the 6-hour rule? Why are they ruling in this way?
Well, for the vast majority of Americans, this will have absolutely no effect on them. This is only dealing with federal court cases, and in most federal court cases, this will not even apply. This comes out of a 1968 law that was passed by Congress. They discussed confessions that were obtained by federal officers, and that only voluntarily given confessions could be used. Now, this is pre-Miranda. The second part of that is that this defendant's statements can be used if the confession was made or given by such a person within 6 hours immediately following the arrest. That is because there are so few arrests in federal crimes that are not planned out and have had indictments through the federal system. So what this boils down to is if somebody is arrested on a federal offense, they have 6 hours to get the confession if they can get the confession voluntarily, and then they must be taken before a judge. And at that point, they're given counsel.
Let's talk about one of the issues that sparked my interest in this ruling. Justice Souter wrote that there is an inordinate amount of cases where somebody is proven innocence through DNA, but they've ended up given a confession at some point. Why do people confess when they deep down know they're not guilty?
Well, I think the same can be asked for why do people capitulate to their spouses after hours of nagging, even if they don't want to go do something.
I know, but Michael, these are bigger consequences. When you confess to a crime, it's more problematic than having to sleep on the couch.
Well, that may be true. However, the incident that we're dealing with was a case of a gentleman named Corley, and that had to do with a 2003 bank robbery. And they kept him for 30 hours of questioning. 30 hours of questioning not only breaks down and you begin to feed somebody information, but it's as the mind is kept awake, is not allowed to rest. Studies have shown that they actually absorb the facts given and then, in essence, dream them into reality and then begin to give small details that have been given some other time during the confession or during the interrogation.
Now, this ruling has no implication on the state level. Is there sort of an unspoken rule that among police officers, for example, that you kind of, if you're going for a confession, you have kind of an unspoken time limit?
No, there is nothing on the state level. I mean, you have to be brought, if you're going to charge somebody, you have 48 hours to bring them before a magistrate for probable cause to determine whether they can be held. And so the police on certain tricky cases will arrest somebody on, and remember it's 48 hours dealing really with business days. They'll arrest somebody on a Thursday night, and they won't have to be brought to court until Monday morning. So you do have an extended period of which you can come into contact with these people. For example, in California, certain prosecutorial agencies are requiring law enforcement now to tape record all of the interaction with an inmate or suspect because, for this very reason, they want to be able to test the credibility of that statement so that a suspect later on can't say that they were forced to confess and something wasn't true. And you can go back, look at a transcript, and see whether the person, in fact, was the first person to make that statement about the crime or they were fed the information by law enforcement.
Appreciate your time and your perspective here. Once again, my guest is Mike Kraut. He is an attorney in Los Angeles, a principal at the Kraut Law Group. He's a former prosecutor. Hey, Mike, thanks for your time.
All right. Have a good day.
This is Scott Drake. You're watching the Legal Broadcast Network. This is Scott Drake, and we know that as an attorney, you're very busy. That's why we have more content just like this at your fingertips, conveniently located at legalbroadcastnetwork.com. Thanks for watching.